Thank you for joining us today for our webinar on the National Defense Authorization Act, Section 889. I'm Angela Stiles. I'm a partner in the Washington, D.C. office of Aiken Gump, and I'm joined today by Chris Chamberlain, an attorney with our International Trade Group, who specializes in international trade, defense, and cybersecurity. And I will say it's critically important to combine the skill sets of government contracts and international trade for your company to be able to appropriately address all of the issues that have been raised by Section 889. So let's get started. First, with the agenda, we're going to go through an overview and some background. We're going to talk about the scope of the prohibitions, which includes a number of important definitions or definitions that you may be able to use more flexibly. We're going to talk in detail about the prohibitions themselves. There are three. There's a procurement prohibition, a use prohibition, a grant loan prohibition. And then we're also going to talk about the required representations and reporting, representations for prime contractors and reporting for both prime subcontractors and potentially suppliers that are lower down in the supply chain. And finally, we're going to cover some of the compliance issues, potential liability, and ways that you may be able to mitigate liability as well. So let's go to the overview first. For a little background to set the table here, Section 889 was part of the National Defense Authorization Act passed in 2019. It was the culmination of many years of efforts by Congress and the executive branch dealing with Chinese telecommunications as security threats. But in particular, I will say the most contentious of those were the Chinese company Huawei. The policy rationale for Section 889 was largely national security. But I think the federal government wanted to ensure the security and integrity of communications networks, information gathering, and they wanted to promote alternative providers as well. So you certainly had a combination of issues that came together, and I think you see developing still as well. The state of our relationship, the United States relationship with China, is particularly important, particularly as contractors are looking for delays or changes to this law. The more heated our relationship with China gets, the less likely any potential delay or change in the near future becomes, which also makes the flexibilities that we're going to talk about in the compliance programming all the more important. A lot of companies and a lot of people were waiting and hoping for a delay in the implementation of this second prohibition, the Contractor Use Prohibition, but that doesn't look like it's coming, and August 13th is right around the corner now. So it's quite important to understand, particularly from a liability perspective, what is expected of you, when it's going to become effective, and what you can do to potentially mitigate the impact of this. But there are indeed three prohibitions, all of which have fairly important definitions in them. So we have a procurement prohibition that's been in effect for almost a year now. It prohibits federal agencies from entering into a contract for equipment, systems, or services that use covered telecommunication equipment or services as a substantial or essential component of any system or as a critical technology. Now, the defined terms in here are going to be covered telecommunications equipment or services, substantial or essential component, and critical technology. We're going to walk through each one of those. Second prohibition, the one that is probably causing most of you to be on this webinar today, is the Contractor Use Prohibition. It is extraordinarily broad and again has some very significant definitions in here. So same definitions as you had for procurement prohibition in terms of covered telecommunications equipment or services, which is actually just a defined set of companies and their affiliates, which we will talk about. Substantial or essential component, again, is defined, and critical technology is defined, just like the procurement prohibition. But what is different here is you have very important terms. What is an entity? That's going to be the prime contractor, or the entity submitting an offer then hopes to be the prime contractor, and then use. And there's going to be some flexibility around the term use, how you define it. It is not defined in the regulation, but certainly there are some topics here to talk about. Is selling an equipment or service, does that constitute use when you're not actually using it yourself at the company that's the prime contractor? And finally, I will call it the largely ignored prohibition that actually goes into effect August 13th itself. It can have a very substantial effect on universities, hospitals, state and local governments, nonprofits, any entity that received grants or loans from the U.S. government after August 13th, 2020. All we have is a proposed rule right now, so we can only rely on what the actual statute says, which is here, and we're going to talk about this in more depth. But this prohibition, considering the number of entities that are grant recipients, cooperative agreement recipients that are not also federal contractors or subcontractors, is fairly substantial. This grant or loan prohibition could cause a number of concerns for entities that aren't used to dealing with the federal government in the same way. So let's talk here a little bit about the scope. So what are covered telecommunications equipment or services? The statute actually defines the companies that are covered by the prohibition. So you have telecommunications equipment or services, Huawei and ZTE. I will say, as I started out this presentation by stating, Huawei has had a fairly contentious relationship with the U.S. government, is probably the primary reason for many of these restrictions. But you also have a list of companies for video surveillance equipment or services. And telecommunications or video surveillance services include services provided by such entities, even if they're just using non-covered equipment. So if Huawei is providing the service, it's going to be covered. Or if you're a company that's providing the service using covered equipment, even if the entity providing the service using a covered equipment is not one of the entities covered here, that is still prohibited as well. Finally, and very important to remember here, is there are a number of thresholds and statutory exclusions. There was an excellent webinar by GSA last week about some of these issues. And one thing that was very clear to me is that the GSA, every time it was talking about this prohibition, said the first question you need to ask is this telecommunications? And so I haven't included that on the slide, but I think it's a very first important question. And we'll talk about it a little bit when we get to the procurement representations as well. But step back, because a lot of times we dig right into the prohibition without stepping back and saying, well, wait a minute, is the government buying telecommunications equipment or services? Is what I'm using telecommunications equipment or services? And ask that first fundamental question. I will say the second question to ask, which a lot of companies fail to ask too, is it a product that is an equipment? And so FAR 2.101 actually defines products and supplies and includes equipment within that definition. So equipment is a subset of products and supplies. So there's some flexibility here where you're providing products that are not equipment. So always ask that question. And then with regard to the prohibition, it's going to be a little bit different when we're talking about the straight up representation. But for the actual prohibition itself, it's only prohibiting substantial or essential components or critical technology with this equipment, system, or service. But it's defined broadly. So substantial or essential component is defined as any component necessary for the proper function or performance of a piece of equipment, system, or service. But I think as you think through how you mitigate the effects of this, it's important to think through what is substantial or essential. How do we approach that? What is our consistent definition, and how do we disclose that to the government? If we have to represent that we will be using, or that we do use covered technology, or we will be using it in the procurement with the federal government, then how can you then be able to provide it because it's not substantial or essential? So there's a big difference here that we're going to talk about between the representation and the actual prohibition itself. So to bridge the gap between the two, you've got to think about, well, what's in there that we use or we provide to the federal government, and is it substantial or essential? There are also two statutory exclusions. One of them has to do with telecommunications equipment that can't route or redirect or doesn't permit visibility. And we'll talk about this again as well, because an important distinction is it physically cannot route or redirect or permit visibility, or you're able to turn off that function. And finally, the last statutory exclusion is for prime contractors that are providing a service that connects to a third party for backhaul, roaming, or interconnection agreements. These terms are also defined terms, and we're going to talk about that. But I'm going to turn it over to Chris Trainborn to talk through substantial or essential and some of the other definitions as well. Chris, I'm turning it over to you.
Great. Thanks, Angela, and it's great to be here on this today. So we'll step through these four thresholds and exclusions, starting with the substantial or essential component threshold that Angela mentioned. So remember that for a use to be prohibited, it has to use covered equipment or services as a substantial or essential component or as critical technology. And as Angela mentioned, that's essentially defined to mean necessary, a necessary component. If it's not lost on you, the government has acknowledged that circularity, and they've noted that what is necessary doesn't really provide a lot more clarity about what is or is not covered. So in theory, this is going to act like a de minimis threshold, where there must be certain uses that are not necessary. There must be certain components that are not necessary. But in practice, what will happen is each agency will interpret it differently. And it's entirely possible that one agency will interpret substantial and essential to mean one thing, and another agency will interpret it to mean something else. And to follow up on Angela's point, so in practice, that means you need to be prepared to explain how and why a particular use is not substantial or essential, among other things. So the next threshold is critical technologies, and this is partly a function of Section 889 having been included in the same legislative vehicle that included FIRMA and ECRA, which were the updates to foreign direct investment and export controls authorities. So critical technologies, it's not defined in Section 889. They've essentially imported the definition from FIRMA, and basically it means items that are subject to export controls and are on an export control list. However, that's not all export control lists. So there are some controls that are subject to what are called multilateral controls, which essentially excludes items that are only controlled by the United States. So in practice, why is that important? It would exclude most common devices, or so-called mass market devices or consumer devices, like phones or computers that are only subject to very low levels of controls. So in practice, and something we'll get to in much more detail later on, because substantial or essential, that threshold is much broader, that's more likely to be the focus of any determination, whereas the critical technology bucket is narrower in scope, but is more precise. You can read a definition, you can look at a list and decide whether something is a critical technology. But again, that also raises Angela's point at the outset that that could involve trying to assess a classification of a component or of an item, and so then you'll see there is some overlap here between this disclosure and what you would consider trade compliance. So I'll step through the next these exemptions. So Section 889 excludes certain things from its scope, and an effective way to think about these is there's a service exception and there's an equipment exception, and they don't do similar things, but one only applies to services and the other only applies to equipment. So the service exemption, as Angela mentioned, it's to provide a service that connects to the facilities of a third party. So that is the core of the service exemption. And we've listed here, as defined in the recent interim rule, exactly what each of these terms means. They're not perfectly precise, but they have a lot of utility, and contractors have had success using them so far to identify certain services as qualifying for an exemption. However, the show here is the limitation in the statute applies only to a government agency that is contracting with an entity to provide that service. So what does that mean? We're talking about the use prohibition. That's what this recent interim rule covers. So in the interim rule, the government makes this express, what you see here in the text of the statute, which is awkwardly that this exemption does not apply to a contractor's use of the same service that could be exempt under Section 889A1A. So you cannot use the same service that you could provide to the government as a result of how 889A1B is crafted, and we've noted this language here. So something to consider. We expect that there will be some focus on this in public comments on the rule. However, the utility of that may be limited by the fact that this limitation is actually in the statute itself. But I think at some point the government will have to reckon with that distinction. So we'll wrap up this section by discussing the equipment exemption, which states that nothing in Section 889 shall be construed to, quote, cover equipment that cannot route or redirect or permit visibility into any user data traffic that it handles. So first thing to note about this, it only applies to equipment that cannot, as opposed to does not. So it only applies to equipment that cannot perform the described functions. And GSA has noted this in recent guidance, that it would not apply, for example, this is a potentially really important example, it would not apply to cover telecommunications equipment installed on a closed network. So, running an intranet, right, that is not connected to the broader intranet, or does not, facilitate communication between two entities. So just to sum that up, then the exemption generally will turn on functionality rather than configuration. That said, I think there's an open question whether you can disable functionality to meet the exemption. I think you should be able to do that. If you can accomplish that and meet the letter of the law there. The examples have not been very clear to date. And in fact, there really haven't been any examples provided, at least in written guidance from the government. Hopefully this is something that will come out of, the rule as it gets applied and, through the comment period. But at the very baseline, it's going to cover things like wires, cable, fiber, but remember that's going to only be the actual cable, only the actual fiber. So, everything after it leaves your device, until it hits another device. But, it's not really clear how much utility there is here because you're going to have to do some kind of processing and routing on the other end of a communication. That said, it should include things like a passive hub or a power supply, fans, metal, plastic chassis and casings and things like that. So, thinking at the component level, whether you actually have equipment that's produced by a named entity that can route or redirect, and this could potentially be a narrow but potentially useful exception. And with that, I'll pass it back to Angela to walk through each of the prohibitions again in a little bit more detail.
So let's walk through the prohibitions themselves. Now that we know the definitions and we understand the thresholds and exemptions, we're going to walk through them in a little bit more detail. The first one is the procurement prohibition. I'm sure that most of you on the line right now have been dealing with this procurement prohibition for the year now that it has been in effect since August of last year. If you have entered into a new contract, extended or renewed a contract, then you are fairly familiar with this. and how it is working with the federal government. So let's talk about it in a little bit more detail, just to be sure we have a common understanding here. So it doesn't apply until an entity executed a prime contract, modified a prime contract, or accepted a new order after August 13th of last year. We always advise people to check their subcontracts and supplier agreements to make sure they understand what they have committed to so far. Also very important are the general exclusions and exceptions that are listed on page 8 that we already went over. So there are 4 of them. Is it a product, not equipment? Substantial or essential? Can it route or redirect? It can't route or redirect, which is going to be the equipment exception. And then the last one is the backhaul, roaming, interconnect, or service exception as well. So always remember, go back and apply those. Representation. So the procurement prohibition has a required representation that must be submitted with an offer, certifying that the entity providing the offer that will ultimately become the prime contractor, if the contract is awarded to them, will not provide covered telecommunications equipment or services to the federal government. This is both, if you take a look at it, more narrow and more broad than the actual prohibition itself. And we're going to talk about that in a little bit more detail, because the representation requires you to really look at more and think a little bit harder than just the prohibition itself. There's also an ongoing reporting requirement we're going to talk about that comes along with the procurement prohibition, and a reporting requirement that must be flowed down to your subcontractors at all tiers as well. Now, what we're really here talking about today, because this is a much more difficult one from a compliance perspective, is the contractor use prohibition. Again, we have the defined terms that we have talked about with the procurement prohibition. You have covered telecommunications equipment or services. You have substantial or essential component and critical technology. But importantly, as I've highlighted here, you have 2 other terms that are not per se defined. You've got what is an entity, which is actually defined as the prime contractor, the way the FAR works. Could have been defined more broadly, but wasn't in the interim final rule, that uses any equipment, system, or service that uses covered technology equipment or services as a substantial or essential component. And so use and what is use is very important, and also I think very important in how you mitigate the potential effects of this rule as well. So as I said, entity is not actually defined. The regulations do define what an offeror is, which is the legal entity that's going to be executing a binding contract. So it is the entity that you name in the offer, the entity that actually executes the prime contract. Really important to remember here too is that this prohibition falls within Part 4 of the FAR, and there is not a definition of subcontractor. If you look through the rest of the FAR for guidance and some of the case law, you can come up with a narrow definition of what a subcontractor is or a broad definition. So the narrow definition is an entity that's required for the performance of a prime contract. A broad definition is going to be any supplier, distributor, anybody really that supplies services or supplies to the prime contractor themselves. So very important to remember what is defined and what's not defined, and where you may find some flexibilities in how you interpret the rule. So the contractor use prohibition, again, like the procurement prohibition, does not apply until you execute a prime contract, modify a prime contract, or accept a new order after August 13, 2020. And depending on how large a contractor you are, when your SAM.gov certification comes up, when you expect to be making your next offer to a federal agency, will really drive when you must start implementing and understanding this prohibition. I would say now, because most of you are going to need to make a certification when you actually submit your next offer. But the government is also going to get around to modifying prime contracts, and they're going to be issuing new orders as well. Remember, it only prohibits use by the legal entity that is the prime contractor. The prohibition itself is not actually flowed down to subcontractors. Although the reporting requirement is flowed down in the 52-204-25 clause. You will note, when you go back and read it, that clause is very broad and could easily be interpreted, and is probably the literal interpretation of a reporting requirement for use for prime and subcontractors. Again, if you go back to page 8 in terms of the thresholds and the other exemptions, you're going to be able to apply the equipment exemption, which is the can't route, redirect, or C, and you're going to be able, but the service exemption, the one that deals with backhaul, roaming, and interconnect, will not be applicable. But again, you'll be able to use the substantial or essential component. So if it's not a substantial or essential component, then you aren't going to be prohibited from using it, but you're going to need to be prepared to explain to the federal government why it is not substantial or essential. So if you have to check, does use covered telecommunications technology, equipment, or services, then you're going to need to explain to the federal government why that's not substantial or essential, why it doesn't constitute a covered use. For example, if you're selling it to another entity, but you're not using it yourself. Contractor use prohibition. So the offeror, the entity that will become the prime contractor, the proposed prime contractor, is going to have to make a representation whether you use or do not use covered telecommunications equipment. And so you're going to have to look fairly broadly. This isn't, is it substantial or essential? This is, do you use any of it at all? Do you use any of the equipment from the entities that we listed above? And you also have an ongoing reporting requirement after contract execution because, again, of the way that the reporting requirement clause was drafted in 52-204-25. Finally, the grant or loan prohibition is quite interesting because we've had a proposed rule out since January 22nd of this year. So you have at the very beginning here what is a statutory prohibition that's prohibiting the federal agencies from obligating or expending grant or loan funds to procure versus the proposed rule, which shifts it down to the recipients themselves. So the grant recipient, cooperative agreement recipient, mind you, cooperative agreement is not in the statute. Loan recipients are prohibited from using government funds to enter into contracts with entities that use covered technology. Well, this is broader than the rule, and there's several outstanding issues, and they're important because there are so many recipients of grant funds that are not also federal contractors. If you think about state and local governments, universities, hospitals, tribes, nonprofits. So this is a very broad prohibition that we do not really have any additional guidance on how it's supposed to be used come August 13th. So the statute itself applies to the executive agency, but the grant rules apply to the recipients, as we discussed. The proposed rule added in cooperative agreements, and I will say the proposed rule incorporated the concept of use, where it isn't really in the statute. So it's a fairly troubling and also potentially broad prohibition that really hasn't been explored in depth yet because we don't have a final rule out on the grant loan prohibition. So with that, I'm going to turn it back over to Chris to talk about representations and reporting.
Great, thanks, Angela. So we'll get into the nuts and bolts now of what you will actually represent based on what you find and how those representations relate to the prohibition and how all of this will likely play out in practice. So we've put the two representations that we have up on the screen here. As Angela mentioned, we really don't know much about the grant rule or how that will be implemented. But we put the two representations as they will exist in the FAR as of August 13th. And we'll just point out some key features. So remember, as you're thinking about each of these representations, they're made from the perspective of the prime contractor. So these are under FAR 52204-24, right? So this is the representation clause. So these are going to be prime contractor representations to the agency counterparty. So we'll talk through the procurement representation first. So the key term here is provide. This covers providing items or equipment and services to the government. But notice what you don't see here. So you don't see the thresholds or exclusions in the representation, and this is where the point of departure is then for the government to make a decision as to whether a particular equipment or service uses covered telecommunications equipment or services as a substantial or central component, or whether an exemption applies. So the use representation. So again, note it is similarly broad. It does not consider the thresholds or exclusions. Again, those are for the government to decide. But you will have the opportunity to advocate as to why a particular use is it does not satisfy a threshold or qualifies for an exclusion. With that said, it provides a really important limitation on disclosure, and that is that you only disclose what you find as on the basis of a reasonable inquiry. So we'll talk about that in a moment, but that's really important because there are a lot of factors in what will make an inquiry reasonable, and it does provide a certain amount of discretion and leeway for contractors in providing an accurate representation.
I think this is very important for people to realize because we have a lot of clients that are confused both as to the breadth of both of these representations. They are very broad and they are broader than the prohibition, but also what it means if you check will or does use covered telecommunications equipment. It doesn't mean you have to have a waiver. So you check these off, and then you provide to the government an extensive explanation, as extensive as you want, is why they aren't, the covered telecommunications equipment or services aren't actually prohibited, whether it's they're not substantial or essential, whether it's not really the use that you think it is. Also, it gives you the opportunity to explain the due diligence you've done for reasonable inquiry. It's so important to remember that government knowledge is an affirmative defense to a false claim. There will be lots of relators out there that will be looking to see on sam.gov or with your next offer how you check these boxes. And for some large companies, it will be tough for them to credibly check will not or does not. And that's where I think Relators Council and relators are going to be looking to target companies, but it also gives you the opportunity to supplement, to give the government the knowledge of what you have done, how you interpret this. I suspect they are going to be very willing to take interpretations of both of these rules. How did you define substantial or essential? What did you consider use? What kind of due diligence did you do as well? But with that, Chris, I'll turn it back over to you for reasonable inquiry.
Great. Yeah, and so one of the biggest questions coming out of the interim rule is exactly how much you have to do before you can provide an accurate, a reasonably accurate representation. But the interim rule does give us some information about where the floor is. So they say that the inquiry should be designed to uncover information in the entity's possession. They mention documentation and other records. There is a limitation that you're looking for the identity of the producer or the provider. It's unclear exactly how much you get out of that. Probably most importantly, it excludes the need for an internal or third-party audit. So what does that mean in practice? So probably three things. We think you can interpret the term or the phrase in the entity's possession to mean that it's reasonable to start with information that you already have. there's a question about whether it's reasonable to limit yourself to information in your possession, primarily because the interim rule, the government does discuss its expectation that there will be supplier engagement. There will be some engagement to find out whether you, as a prime contractor, use a service that triggers the representation. But with that said, so I think the second practical piece here is, you can take a risk-based approach to subcontractor and supplier engagement. And certainly there may be suppliers and subcontractors that are more likely or less likely to provide you services that would trigger your representation requirement. And the last bit is that, it includes a time element. What is reasonable on August 14th in 2 weeks is likely very different than what will be reasonable after the rule has had time to circulate in the industry, and there may be more guidance issued. So it's something to consider as especially for contractors who might not make their representation as a prime contractor for several months or even into 2021. We want to talk a little bit about the impact. So what happens after you represent? That you will provide, or that you do use, or that your entity does use. The interim rules, both for A1A and A1B, the procurement and use prohibitions, they spell out exactly what kind of information you need to provide. And that includes these two first bullets here. So there's going to be some pretty detailed information about any covered equipment, and especially anything that is offered to the government. But then more loosely defined is this, quote, explanation of the proposed use and any factors relevant to determining whether it's permissible. So this is where the rubber meets the road on this gap that we talked about between the representation and the prohibition. So you check yes, or you check will, or you check does. You will have that opportunity to explain the use and provide factors relevant for the government to determine if it's permissible. So once the government has that information, what is it going to do? It will use the package of information that you've provided to determine how or whether the substantial or essential or critical technology thresholds apply. It will determine whether an exception may apply. And maybe most importantly, it will determine whether an exception applies. And it will use that information to decide whether to request a waiver. So there are two waivers. We'll talk a little bit more about this, but it's actually the government's right to request the waiver as opposed to the contractors. And this information package is sort of the basis for that. If you get to that point, and or you're actively seeking a waiver, you'll also have to provide what they're calling a laydown or description of presences. So our interpretation of that is something like a network map. Maybe that's too detailed. There's no prescribed form, but something that shows essentially the range of uses that you've discovered during your reasonable inquiry. And then the last bit would be a phase out plan. So to put this together visually, especially since we're focused on the use prohibition today, we wanted to lay out visually, how this works and where there's some certainty and where there's significant ambiguity. So again, to step through the representation will cover a use of covered telecommunications equipment or services, or a use, again, any use of equipment, systems, or services that use covered telecommunications equipment or services, period. Very broad. It covers things that will not be covered by the prohibition, and it will cover things that are not covered by the prohibition, because the prohibition also requires that use be as a substantial or essential component, or as critical technology as part of any system. And also, you would have to factor in the exceptions. And so, something to draw your attention to in this visual representation, you can see the outer band is everything you find. So this is everything that you find during your reasonable inquiry. any use that you discover by the legal entity that is the prime contractor uh, presumptively will trigger the representation, obviously notwithstanding some of the other thresholds that Angela mentioned. Whether something is actually a use, is a good one, whether it's actually by that legal entity. Those are all part of your reasonable inquiry and things you should think through. And then there's the smaller bucket of uses that actually trigger the prohibition. And we've tried to highlight here that critical technology is in some ways more defined. It has a more precise definition. You can go find the definition somewhere else in a regulation. And the substantial or essential threshold is not well defined. I think it's generally will be left up to agencies to determine. And we tried to show that here by showing that there's a fade. So somewhere above the substantial or essential threshold or below it, something would not be prohibited. But it's unclear exactly, where that line is. So some other implications of a representation. One of the most significant is going to be an ongoing reporting requirement that will apply at least to prime contractors and potentially any subcontractor that accepts the 25 clause. So in the interim rule for Section 889A1A, which was effective last year, the FAR Council established a reporting provision that you see here, which essentially requires any contractor subject to the 25 clause to file a report in the event it identifies or is notified of any prohibited equipment or services during contract performance. So since the more recent interim rule did not amend this language or really address it, it can be read to require reporting of any prohibited use that's identified during contract performance. And again, at any tier or from any other source. And maybe the main reason this is so notable is that it has a 1 business day turnaround to provide details about that equipment or service in question, followed by subsequent reporting 10 days later, essentially identifying the plan to mitigate that use. Great. So we're going to talk a little bit about how this all comes together. And the word compliance plan doesn't appear in the actual text of the regulation, but they describe it in the interim rule as encompassing all of what we just talked about. So it's going to include these elements that you see here, and importantly, there is some expectation that this will be part of a program. There will be efforts undertaken after a representation, to ensure ongoing accuracy and also reporting. And we add a little bit more information here on waivers as well. So the primary takeaway here is the distinction between the 2 waivers that are available. So there's really a temporary waiver. Waiver is not the most precise way to describe what is authorized by Section 889. Essentially, it's a waiver through a certain period of time after the effective date. So it's not a permanent waiver in general. And again, as we mentioned earlier, it's requested by an agency, right? So it's requested by the entity that you are contracting with, and they have to get approval from the head of their agency to authorize a waiver. And the timelines are worth noting here. So with respect to procurements, you can have a waiver through August 13th, 2021. And with respect to use, you can have a waiver potentially through August 13th, 2022.
And I think with regard to waivers, it's very important to remind everybody that they will be few and far between, one. But second, just because you check will or does use, will provide or does use, does not mean you have to have a waiver. Only if you're going to be using the covered technology for a prohibited use. So if it's substantial or essential, as an example. But quickly, we also created a few recap slides for you here. So you can think through how you're going to encounter both the procurement ban and the use ban, depending on whether you're a prime contractor or a subcontractor or another entity in the supply chain. And remember, other entities in the supply chain could be suppliers as well, depending on how subcontractor is interpreted, how you interpret it, and how the government interprets it as well. On encountering the contractor use ban, again, it's the same kind of a calculation. So how am I going to counter as a prime contractor? What use do I look at? What am I going to see as a subcontractor? Are they going to ask me to make a certification, to make representations, request for information? I would expect a pretty, broad array of different requests coming in from prime contractors to subcontractors and even to suppliers as well. So it's good to start being prepared. If you know that you're in the federal supply chain, then you should definitely start thinking through, what am I going to do? Even if I'm just a subcontractor or a supplier, how am I going to approach this? So now let's turn to liability, compliance, and potential mitigation measures. So there are regulatory compliance concerns with export compliance, supply chain security. There are also the normal things to think about as a government contractor or subcontractor: contract termination, breach of subcontract. So if you end up supplying or you misrepresent, you should expect contract termination. You should expect the government or the prime contractor to consider it a breach of contract. This can affect your past performance ratings. I would expect audit and investigation. I would expect expenses from that. So you're going to have inspector generals auditing, investigating, and you're going to have Congress ultimately auditing and investigating this. You have to think about suspension and debarment. So if you make an improper representation or you don't report on time, you shouldn't be surprised if suspension and debarment is one of the remedies that the government considers. And then there are also just commercial contract remedies between prime contractors, subcontractors, and suppliers. So, you may be in the supply chain, but the remedies are going to be commercial contract remedies between two commercial entities. Chris, I'm going to turn it over to you for export compliance and supply chain security.
Great, thanks. So these first 2 points might not seem to be part of the core of liability considerations under Section 889. But we wanted to mention them because they highlight the kind of overlap here between government contracts and trade, and there are very real considerations to make, not only presently, but kind of looking forward and thinking about the foundation that Section 889 is forming. So the first thing that we'll mention is just that. So as a result of there being certain affiliates of 3 of the entities named in Section 889 on the Commerce Department's entity list, the reasonable inquiry is likely an appropriate time to consider whether any of those activities that you identify raise export compliance concerns. And then supply chain security. So I'll mention just the first bullet here, that there is a corollary provision that is in the DFARS that is sort of an enhanced version of Section 889 specific to nuclear deterrence and homeland defense missions. And that rule, there's a DFARS rule that effectively implements 889 and the Section 1656 of the prior year's authorization for the DoD. And then we mentioned some other initiatives here. We note that there are rules pending, or second rules that are forthcoming, because we anticipate a lot of the infrastructure, the regulatory infrastructure, best practices that that companies and agencies form as a result of their efforts with respect to 889 are laying the groundwork for expectations that will necessarily arise in other areas. And the reason we mention these 3 in particular here is that the scope of these has been discussed as overlapping with what is covered by Section 889, and it is possible that some of these other initiatives will take a stricter or maybe looser, but potentially stricter approach to even 889's very broad prohibitions. So I'll stop there on these, and I'll turn it back to Angela to talk about the more core kind of contractual remedies that will arise or that may arise with respect to Section 889.
So no government contracts presentation will be complete without a discussion of the False Claims Act. You do have to think about this, particularly with regard to the representations you're making in SAM.gov or with each individual offer, where you're saying you will provide or you do use or don't or won't, depending on how you check those boxes. I will say that relators, the Relators Council, plaintiffs' attorneys will be looking closely at that, and they'll be looking at the credibility of the company that says that they do not use covered technologies, because it's not substantial or essential use, it's any use. So think about that when you're checking the box, and think about, as we'll talk about in the last slide, how to mitigate that particular representation, because it's going to be a very important one to consider, both in terms of the government's reaction, as well as the potential outsiders, potential private attorney generals under the False Claims Act. Don't forget the elements of the False Claims Act. You've got a claim here. You'd have a falsity if your representation is not correct. The government, I do believe, would consider it material. And what's really important is knowledge. Do not forget that False Claims Act, Civil False Claims Act liability can be based upon reckless disregard. So if you're just checking the box without doing more, without the reasonable inquiry, without due diligence, without the compliance plan, there's going to be a focus on whether that was reckless disregard or deliberate indifference. Don't forget also the extent of the damages. They can be quite significant. As you know, the government often pursues treble damages or of the value of the contract in these situations, which can be quite large for many companies. And finally, just a little bit of discussion about mitigating your liability. You know, we've talked a lot about checking the box and then providing additional government information to the government after you check the box. So if you check will or you check does use, you can provide a significant amount of additional documentation to the government. So my mantra is always disclose, 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 because government knowledge is an affirmative defense to the False Claims Act. And so always be thinking of that. I mean, if you check will provide or does use, it doesn't mean the government isn't going to contract with you. It doesn't mean you're going to be excluded from the bid, and it will help you prevent or be able to raise affirmative defenses if you have later False Claims Act cases. And I suspect, you know, as the plaintiff's bar looks for places to go, they will be looking here as well. You should also realize that as a prime contractor, you can flow down a lot to subcontractors. They hate it. You know, there are mandatory flow downs. There's non-mandatory flow downs. There are plenty of representations and certifications that I've seen on the procurement prohibition, and I suspect I will see many on the use prohibition as well. If you're a subcontractor or supplier, if you can do it, you're going to want to push back on those things. You're going to want to push back on your potential liability if you didn't get it quite right. You're going to want to push back on non-mandatory flow-down clauses. You're going to want to say, well, that representation actually isn't required of me. What else can I give you to give some comfort that you are not using because of the service or the product that we're providing to you? I have seen certifications as well, not just representations. So I do think that each company, particularly the prime contractor, needs to consider their risk tolerance here with regard to how they make these two representations. And I think you also need to explore, document, and disclose if you check will provide or does use in your representations. And you're really going to need to explore and document and disclose your arguments on use, your arguments on substantial or essential. You know, as I said, there are a lot of questions around use. It's not a defined term. If you sell a product to another commercial company that is covered by the prohibition, is selling really use? And I think that's an important thing to explore. And if you want to continue selling to other commercial companies, make sure you disclose and explain to the federal government that it's not a use. Again, I'm going to end with disclose, disclose, disclose. Even if you check no on these certifications, find a way to make sure that the government knows and understands your interpretation, so it will ultimately be government knowledge when that contract is executed. And if there is a False Claims Act relator later in time. But I'm sure this presentation has raised a lot of questions for you. Please feel free to contact us by email or phone at the email addresses and numbers that are listed in our contact information. Many of these questions are very complex for our clients. We understand that. And we're happy to work with you to work through how to mitigate liability and how to mitigate the impact of these prohibitions as well. But thank you again for joining us today. We appreciate your time.